the perspective that I take is that my job as a defense attorney is solely to be the safeguard to a fair and just trial. And so I'm not even necessarily looking at it from the perspective of my client. I'm looking at it from, look, I need to ensure that the police did their job correctly, that the prosecution are doing their job correctly, and that the judge is doing his job correctly. Because at the end of the day, if those three entities have done their jobs correctly, well, my case is supposed to end in a guilty verdict. And so that's why it's really easy for me not to necessarily even focus on the guilt or lack thereof with regard to one of my clients. It's really just ensuring, at least first and foremost, that the entire process is fair and just.
Hey, Lucas, welcome to All Things Crime.
Thanks so much for having me, Jared. It's a pleasure to be on the show.
Oh, the pleasure's mine. You know, I have to admit, you are the first attorney that I've actually had on the show.
Perfect. Well, I'm excited to be the first and hopefully have a great conversation.
Yeah, well, you need to represent yourself well.
True, not only myself, but obviously in my field as an attorney, it's really the representation of the individual that I'm hired to represent.
Sure. So for my audience, I'd like to introduce Lucas Hirsty. He is an attorney down in the San Diego area, and he's also a new podcaster. We'll definitely talk about that, but members of the jury. Lucas, why don't you introduce yourself and tell us a little bit about how you became an attorney, and then we can get into your podcast.
Sure. Thanks so much. So I'm currently working as a deputy public defender. So the best way to make that representation is with the historic, Miranda warning that everybody knows from Hollywood and other TV shows that says, you have the right to an attorney. If you cannot afford one will be appointed to you. And then so that's where I come in. A lot of my clients are indigent. They don't have a lot of income, but the key or the right to have criminal representation or representation when charged with a crime, that's a forefront in our Constitution. And so that's what I do on a day-to-day basis. And where I currently work, our courthouses, like a lot of the country with COVID, have been shut down, going on a month now. And I became an attorney solely so that I could do jury trials. I really love that. I think the ins and out of a trial are something that are very engaging and exciting, and obviously have a lot of severe magnitude on both sides. And so I really love the art of trial work, and that's what Members of the Jury podcast is really focusing on. The whole premise was, if jurors can no longer come to me, well, I'm going to go to them. And so we talk a lot about jury trials. We speak to some attorneys who did jury trials, and we'll also talk about aspects of criminal justice reform.
Wow, very interesting. So tell me something about jury trial that most people wouldn't know.
I think the hardest thing about a jury trial is all of the ins and outs and I's and T's that have to be gone through before you actually get to the jury trial stage. I don't think a lot of the public or those who are even in the jury realize all of the things that happen behind the scenes, and that are in play with regard to a case, especially because, not everything that potentially is a part of the case actually gets presented to the members of the jury. There's a lot of times where the lawyers are in the courtroom without the members of the jury, just speaking to a judge about certain legal bases or issues that are involved in the case. And then obviously, depending on how the judge makes his rulings, well, that will determine whether or not the members of the jury actually get to hear a certain piece of evidence or see a certain piece of evidence. And that could be the thing that makes or break a case, honestly.
Wow, fascinating. That is one of the areas that honestly I haven't had any real part of. I'm not sure if you know really what the MVAC is, but it's for DNA collection. And so the MVAC is literally on the other side of the process, at the very, very beginning, whereas obviously you come into play at the very end. So it's interesting that we would come together and talk about things in this setting. we don't really have much to do with each other, but ultimately we do, because the evidence that might be collected with the MVAC is certainly going to be scrutinized by the attorneys on the other end.
Absolutely. And I think like that's something that exactly what I was talking about, that, could maybe or maybe not be presented to the members of the jury. Anytime you start getting into the realm of evidence collection and kind of forensic evidence, the scientific credibility of not only the instrument, but the individual using it are really important. And kind of the history of the equipment also matters. One of the biggest things that we're always looking at, especially anytime some kind of scientific piece of equipment is used, is kind of like the calibration of that equipment, right? Because most machines need some aspect of routine maintenance or calibration to ensure that the result that it's yielding is in fact accurate, because we would never want an inaccurate piece of evidence to be presented to the members of the jury, because we don't know how that's going to sway them. And so I think that that was a great segue, because that would be something 100% that I would imagine, should the NVAC be used in a collection or evidence collection, the attorneys would most certainly argue about whether or not the admissibility of it is valid or not. And I'm sure that you would maybe have to come in and kind of give some of the historical background about the piece of equipment and kind of lay down the foundation so that we know the result is authentic.
Absolutely. We've actually nobody from my company has actually ever had to appear on the stand, but we've certainly provided a ton of information to especially the crime scene investigators and the crime lab people that have used the equipment in collecting the evidence. So and all of our sterilization techniques, all of those kind of things, like you said, the calibration. Our system really doesn't require any kind of calibration, but we do offer like an annual maintenance program to most agencies, and most agencies take us up on it, because frankly they don't want to sit on a stand and be scrutinized by somebody like you and say, well, we've had this piece of equipment for 4 years, and yeah, we kind of go through it once in a while, but it hasn't really been maintained. That little tidbit to the jury might sway the case, and so they definitely don't want to do that. But yeah, the Daubert Fry type of hearings that they have, to me, that's one of the most interesting things about when you introduce scientific evidence. So why don't you talk a little bit about that?
Absolutely. So anytime that a case is trying to introduce some aspects of forensic science, there's a very scrutinized legal standard that is required in order for that to get in. Certain cases out there have laid that groundwork that I believe it's a 4-pronged test. And basically that test is ensuring that the forensic data or data that is being introduced into evidence is authentic and accurate. We've seen over the history of criminal justice how forensic science has evolved. Although there have been amazing advances in that field, there have unfortunately been moments of junk science where, at the time of a trial or testimony, an expert took the stand and was testifying and introducing components of forensic science, but that later we were able to determine, unfortunately, that science was not accurate or was not authentic. And so over the course of time, there's been a 4-pronged test that has been established that either side, or, even if we cross over into the civil realm, even when you're dealing with forensic evidence in a civil realm, the Daubert Fry test also applies to them. And it's really just trying to ensure that, we're not able to manipulate science, because a lot of the times, and the reasoning for an expert testimony is to be able to break down that science and explain it to the members of the jury, because so much of the information is kind of above their level of expertise or even comfortability, even with attorneys. That was one of the things that I didn't realize was actually a component of being an attorney until I became one, that I have to become so familiar with so many other factions out there besides law, so that I can then make a bridge between the law and the case. And so, for example, if I ever had a case that involved an MVAC, Well, I would need to do so much research and analysis of NVAC so that when I'm, potentially crossing you or crossing any of the evidence that came as a result of the MVAC, I'm able to understand the MVAC and then break that down to my points in a way in which the members of the jury would better be able to understand. One of the reasons I think that the Daubert-Frye test was established was, a lot of people know about Ted Bundy and his whole trajectory of everything. And if you watch a lot of the Netflix series or Hulu documentaries, they talk about just this. And that in one of his cases where he actually was convicted, there was dentist bite marks evidence that was testified to and put into evidence. After some years later, and I think going back and trying to apply this Daubert-Frye test, they realized that bite mark dentist DNA or evidence didn't actually amount to the level of authentic and credible science. And so now that kind of evidence isn't allowed in a courtroom. Same kind of thing with a lie detector test.
Yeah, there's also other forensics evidence that maybe 20, 30, 40 years ago would be mainstay, like hair analysis, for example. I mean,
Right.
there's different ways to analyze hair, and the way that they used to use can't be really applied in court anymore. But I think DNA is just exploding and is becoming basically the gold standard. And for good reason, is because it's so differentiating. If you have a good DNA profile, especially now, they've expanded the number of markers from 13 to 24, that if you have a 24 marker DNA profile, it may be 1 in 1 trillion that it's not that particular person. When you get into some kind of aspect like that, then that's pretty solid evidence. So
Exactly. And the good thing about DNA evidence is that, because of the accuracy that it's able to generate, we see positive results on both sides. We see more confident convictions, and we've also seen exonerations that have come out of result of good forensic DNA evidence. And so I think at the end of the day, all of the lawyers who are involved in the field, whether it is criminal or whether it is civil, they want the best evidence there is. And, there might be disagreements between the attorneys as to if the evidence being presented, is that. But ultimately, I think that having the field of forensic science is crucial, especially in the field of criminal law, because making sure you have the right person, at least from my point of view, is such a crucial component of the system. I very much live by the philosophy of I'd rather see, 100 guilty people go free than one innocent person be locked up.
yeah, and fortunately, I think the entire justice system supports that. And
Mhm.
I think the number of people that are wrongfully convicted, wrongfully accused is a different topic, but
Right.
wrongfully convicted, I think, is pretty rare. But to your point, the MVAC has actually been used, and in particular, like with the Chris Tapp case, but there's been others as well where Chris Tapp, I don't know if you're familiar with him, he was wrongfully accused of a murder in Idaho Falls, Idaho in 1996, and he served 20 years for that homicide rape, and was eventually exonerated due to DNA, and actually a lack of DNA on certain areas of the evidence, that had he been there and had he actually participated in the crime, there's no way that his DNA wouldn't have been on that evidence. And so and that was in large part because of the MVAC. And that's just an amazing case, because you also get into the forensics or the genealogical DNA, which is becoming so popular right now. And it's just amazing. That case, I can't talk enough about it, because you go from all the way back to where he was convicted basically on his own confession,
Mm.
and then which he later rescinded, but he was still convicted. Like I said, served 20 years, and then was eventually not only let out on time served, but then eventually exonerated. And due to genealogical DNA, they actually caught the actual suspect. I
Yeah,
can't say
yeah.
that. Well, I'm tongue tied today, but
Perpetrator.
perpetrator, that's the word I was looking for. Thank you.
Of course.
Leave it up to a lawyer to be able to find the right words, right?
Yeah, I mean, me personally, I definitely stumble all those. And one of my favorite stories that a colleague has of mine is like in one of my first trials, like I was kind of so caught up in the moment. I had said, these alleged allegations, just trying so hard to distance my client from the crime that, it definitely happens.
Yeah. Well, it doesn't matter how well versed somebody is, and yeah, the moment can screw up everything. So, especially public speaking, right?
Absolutely, absolutely.
I just had another interview not long ago with an actual professional podcaster. So that's what he does full time, and we were talking about some different things like that. Podcasting actually isn't as easy as some people may think. It's a lot more than just sticking a microphone into your phone and cranking out some amazing podcast that people are actually going to be interested in listening to. So there's a whole art to it, and it doesn't matter what your profession is. Becoming the best in that profession takes time, it takes a lot of effort, and it takes a lot of practice.
100%. I think the biggest challenge to podcasters and podcasting, especially for those who have a level of comfort in public speaking, is we understand that we're speaking to an audience, but there is no actual audience for us to look at, for us to engage with. And so much of me, at least of me and my personal practice of, obviously as an attorney in public speaking, is making that eye contact with the audience, getting a sense of, how are they receptive to what I'm saying? Are they paying attention to me, or are they dozing off? Do I need to change something that I'm doing in my presentation to make them more engaged? And so there's that live feedback that, even if it's just body language, that a public speaker is able to process when he has a live audience or is in front of actual people. That's been probably my biggest difficulty in switching over to the podcast world, is that you just don't know until after you publish it and start to get some reviews and feedback as to kind of how receptive, that episode or that segment was.
Well, that brings up an interesting question. So when you are presenting evidence, you can't actually ask the jury what their opinion is, right?
No. So essentially, there's only two times in an entire trial where you will have kind of direct contact with the members of the jury. And what I mean by direct contact is both a give and take. Obviously, there's moments without the trial where I'm directly talking to them, highlighting a crucial point of testimony or a timeline, because obviously the whole trial is designated towards their focus. But there's only really two times where a juror can actually provide their kind of feedback, and kind of three with a caveat. And the first one would be during the initial start of the trial in the process called voir dire, where the judge, the prosecutor, and the defense attorney will be able to ask questions of the potential jury, and they're given a microphone, and they're given direct answers. And now sometimes we ask all of the potential jurors, by a show of hand and then ask a question. But we're able to get really personal sometimes with jurors and ask them, an individual juror, a question, and then get a response back from that juror. During a trial, if a member of a jury has a question, well, they're able to write it down and submit it, at which point the judge will normally inform the attorneys. And between the two attorneys and the judge, they'll come up with an answer, maybe, because sometimes judges elect not to really entertain a jury question, depending if it's off topic or might send us down a wrong rabbit hole that distract us from the actual trial at hand. So they might not answer it, or the judge will run their answer by the attorneys. And if everyone's in agreement, then that's what will be conveyed to the juror. And that can happen during the trial, or even after the case is submitted to the members of the jury during their jury deliberation room. They're also able to submit questions to the judge at that point in time. And then the last opportunity that an attorney and the members of the jury would have to actually interact would be after the trial. There is a moment where jurors if they choose, are allowed to hang back and interact with the attorneys to talk about some parts of the case, how the deliberation went, and what they thought. And a lot of times, you are able to get a lot of crucial information from that kind of debriefing with the members of the jury. I've seen it both sides where, the prosecutor got us some what they thought was a valuable piece of information from a jury, and then were able to subsequently raise an issue. Same thing with the defense. And so sometimes you're able to, get really vital information. But in my experience, most of the time, jurors, especially at the end of the trial, they've been there for a couple days. They've been away from their families. They've been away from their work. They just want to do their civic duty and get out of there. And so you always have maybe a few who stay back in chat, but it just kind of depends on the case and the individual juror.
Yeah, I would think a lot of that would be dependent on the level of scrutiny, really, of the case. If it's some high-profile O.J. Simpson type case, then I'm sure they would want to milk that for all it's worth. But yeah, like you said, the majority of cases, they're just going to be like, "Oh, I did what I was asked to do, and now I just want out of here."
Right. I mean, they weren't paid that great while while they were doing the jury service. And like you said, if it's not like a high profile case where they might be able to get some kind of media or tell all story, then they've already dedicated a lot of time and money. And although it's beneficial to the attorneys to get that feedback, I don't necessarily think that that's on their mind.
One thing that's I think is really interesting is during a trial, the past, say a suspect is already been convicted of a murder, served some time, and then been released, and then is reoffended.
Mhm.
And yet that person's past, his history or her history, really can't come out during the trial. Why is that?
Well, because I think, and so it depends, obviously, because there are occasions and certain statutes that do allow for, prior bad acts or convictions to potentially come in. But I think the default rule of, really focusing on the facts at hand comes into play because you don't want to have the members of the jury be prejudiced by those prior acts. There is definitely a misnomer that if someone does something once, well, they're bound to do it again. Or especially when you're looking at bad acts, there's a lot of misnomers of, once a thief, always a thief, or once a cheater, always a cheater. And, that definitely might be true for a given individual. But I think to kind of put these blanket statements of, prejudice on people could be really detrimental. And there's also this possibility where if they didn't get a conviction and they were, accused of a crime or, wrapped up in something, well, you don't ever want the members of the jury to be like, well, they got away with it that time. And, even though this case might not be that strong, we want to kind of make up for that prior event. And so it really just serves as a safeguard to ensure that the individual on trial is getting the fairest available. And, once you start getting into facts and scenarios that are outside of the instant case, well, now we have to start questioning what impact does that have on the members of the jury.
Right. And that's exactly why I wanted you to address that, is because when we talked about it at the very beginning of our discussion here, how the entire justice system that we have is based on the actual crime, not any other factors. Because I think that's something that's really unique about, I shouldn't say unique, because I don't know enough about all the other countries and their justice system. But within our justice system, the way I look at it is if you don't have enough evidence to actually convict him for that one thing, then nothing else matters. And the person's past, I know that can come out during the sentencing phase, but for the actual conviction, I think it's critical for us to not have a knowledge of the person's past, because like you said, it may taint the jury. It may make somebody say, well, this guy was convicted based on, or he wasn't convicted last time, and I'm positive that he or she was the actual perpetrator for it, and so we need to make up for that and put down a guilty just because, as opposed to everything that's based on the actual case, the actual evidence, and the actual everything that supports. And we can get into all sorts of different things, like, is it a manslaughter, is it a second degree murder, is it a first degree murder? But
Right.
all of those, just kind of looking at it, how you actually prosecute somebody and the aspects of that. But to me, one of the most critical things about our justice system is that every criminal case stands on its own, and the evidence has to support that particular case as opposed to anything else that's happened in the past.
Jared, I think that's a great point, and it's 100% true. I mean, simply because that information doesn't come out at trial doesn't mean that it's not taken into consideration, doesn't mean that it doesn't play a role in the overall kind of case and, like you said, sentencing. And because at the end of the day, if someone's going to be subject to sentencing on a crime, it's because the state had enough evidence to prove the facts as they were charged in that particular case. They shouldn't have to be relying on previous incidences and contacts to help prove their case. And I totally get where that is helpful. And obviously, that's why the law allows for certain areas when there's a certain charged offense to get into those kind of prior bad acts or convictions. But for the most part, during a trial, they're only to serve as, prejudicial moments, inflame the members of the jury. And at the end of the day, I agree with you. I don't think that they should really come into play until sentencing. And that's the perfect time to do it, because even if they did maybe get off, the judge can take that into consideration just for the fact that that individual was potentially involved or in the area. And so I agree with that point wholeheartedly. And, I think that the law does too, because there aren't that many exceptions that allow for prior bad acts and convictions to come in, because they're aware that that could just be so detrimental to an individual during trial, as it takes, as the members of the jury are trying to determine this individual's, guilt or innocence.
Well, and to that point, what kind of instructions does a judge typically give the jury in regards to, like, say, for example, I mean, there's extreme cases like O.J. Simpson. I think by the time he went through that second trial, there wasn't anybody on the planet that didn't know about the O.J. Simpson and, the glove and all of that drama that happened. What was that, in the 80s, maybe 90s? But anyway, it happened.
Late. I was born in early 90s. I was born in 1990, so I know it was right. Like the whole thing was going on around that time. I
Oh,
just don't recall the exact date of incident.
that's just wrong, man. I can't even tell you. Yeah, my oldest daughter was born in 96. And so, yeah, enjoy your youth. So,
Yeah, so far. Or as my favorite legal movie is my cousin Vinny, and he always says Utes.
yeah,
Enjoy
that's
your
right. Oh, that's a classic, man. I love that movie. Anyway, the purpose of those kind of instructions is basically to say it doesn't matter what you know about this individual, and
Mhm.
you have to be totally blank slate, and you say objectively looking at the evidence and whatever the prosecution and whatever the state presents, that is how this person has to be convicted. And to me, that is the most fair thing that you can possibly have in a justice system, is one of the, that along with other things. But to me, that's during an actual trial. It's interesting that for those of us that are on the outside of the trial and things are progressing, and there's always going to be commentary, there's going to be reporters in the courtroom that are saying, yeah, this evidence being presented in this way. And there's times when I've seen commentary on the outside saying, how can they possibly let this guy go when this kind of evidence is presented? But usually they put it in the context of the guy's past. Well, that's not part of the trial. And I don't
Mhm.
think a lot of people understand that.
That's a fantastic point, because the media and certain components of public record, they can absolutely divulge and put out into the world. That goes right to what we were talking about with the members of the jury. Well, they have to be scrutinized to a certain level of safeguard so that we know those aspects of prejudice. I mean, I think that's just blatantly the way to say it, don't come in and taint their viewpoint of the jury. And I think, fortunately, most cases aren't OJ Simpson, and most cases don't have a lot of media attention behind them, especially going into the trial. And so on a day to day, that's not an issue that, I think attorneys have to struggle with. But that's why I think when you talk to most trial attorneys, they'll tell you that one of the most crucial if not the most crucial part of the whole jury process is that voir dire selection, because you really get an opportunity to have a conversation with your potential jurors to pull out what are they most, what are their prejudices towards, do they have the ability to compartmentalize certain moments of their past that could affect their judgment. I think for domestic violence cases, is a great example, because so many people who aren't necessarily personal victims of domestic violence have really bad prejudices, and rightfully so, towards domestic violence cases, solely based off an experience that they had with a friend or family member who may have been the victim of domestic violence. And one of the things that I always say in my voir dire is that, look, this is a process for me to try to find the right members of the jury for this case. And that might not be you, but that's totally fine. You could be the perfect juror for another case, but not every single person is the perfect juror for every single case, because we all have life experiences and we all have moments that touch us or affect us in different ways. And when you're being the trier or the judge of facts and determining, someone's guilt or innocence and ultimately their liberty, well, the fairest thing to do is not allow any of your personal prejudices to come to the forefront and cloud your judgment.
Which I think as humans is probably the hardest thing in the world to do.
Absolutely.
So what, being in San Diego, have you had much opportunity to look into the McStay case? I'm sure you've heard a lot about it.
I actually am not super familiar with that. I mean,
Okay.
obviously, with the courts being closed down, and so that was one of the things that I loved about being a public defender, was the ability to actually be at the courthouse and just view and get a sense of things that were going on. Big cases or media cases, because as an attorney, being there, you learn so much, and that's, with them being taken away, like, I felt like I've missed out on so much. And it also has taken away from just our ability to kind of even be up to date with our colleagues. One of the things that in my office that is really popular, I guess, is that we talk about our cases, to get different perspectives, to get different ideas. The art of collaboration can be so strong, so unfortunately, I'm not super familiar with that case.
Well, that's it was actually tried, and it's on appeal because
Okay.
the defendant was convicted. Essentially, the reason I asked is because the victims were all from San Diego, and there was a family of four, and in 2010 they disappeared, and some I believe as a motorcycle rider found a skull in 2013 up in the Victorville
Wow.
area. And so it fell under the jurisdiction of the San Bernardino County Sheriff, I believe. So they tried swabbing, they found two shallow graves. It had an adult and a child in each one of them. And the murder weapon was a 3-pound sledgehammer. So pretty brutal crime. And then obviously the victims were buried. But as he was riding his motorcycle up there, saw a skull, what he thought, and so turned around, called the sheriff's department. They came out and they found those two shallow graves. Well, the husband was, for example, wrapped up in like a blanket and had one of those like white extension cords wrapped around him. Anyway, the interesting thing is, even though the San Bernardino County Sheriff's crime lab tried the swabbing methods on the clothing of different victims, didn't get much of anything from that. But the defense actually ordered MVAC testing on it, which is why I'm so familiar with the case. And that's, I wasn't a part of it, but I learned about it after the trial was over and during the trial. I saw a lot of it was pretty much broadcasted because it was such a high profile case, and just amazing, because even though this clothing had been buried for 3 years, they still were able to collect DNA profiles from that clothing. So
Wow.
really, really interesting case. And it's, like I said, it's on appeal now. And so I don't know exactly where it's at, but the fact that the MVAC was utilized in the way that it was, and most importantly, it was by the defense that requested the MVAC testing, as opposed to the prosecution, which is probably, I don't know, 95 to 98% of the time, it's going to be the prosecution that wants
Right.
that DNA profile. So I can just imagine what, as a defense attorney, sitting down with your defendant and saying, look, if your DNA is on that clothing, we better not do this testing because it's much more aggressive than current methods. We already have a negative in our under our belt, and so we don't want, if there's any chance that his DNA was there. I'm sure the defense attorney was like, we don't want to do this. I don't know
I
if you
think that,
have
and
any.
that goes to show the power, though, I think, of forensic evidence. And it's kind of like what we talked about a little bit earlier, whereas I agree 100%, at least, I think 95% is, pretty accurate number as to, the prosecution or the state generally using the higher science forensic evidence. But the fact that it's there and it is able to be utilized by both sides is fantastic. One of the
Mhm.
things that we always say is, especially because I get asked all the time, like, how do I do my job? How do I represent those criminals? And I always tell people that it's honestly not that hard as you think, because it depends on the perspective that you take. The perspective that I take is that my job as a defense attorney is solely to be the safeguard to a fair and just trial. And so I'm not even necessarily looking at it from the perspective of my client. I'm looking at it from, look, I need to ensure that the police did their job correctly, that the prosecution are doing their job correctly, and that the judge is doing his job correctly. Because at the end of the day, if those three entities have done their jobs correctly, well, my case is supposed to end in a guilty verdict. And so that's why it's really easy for me not to necessarily even focus on the guilt or lack thereof with regard to one of my clients. It's really just ensuring, at least first and foremost, that the entire process is fair and just. And that the ability to have forensic evidence available to the defense has been vital. And granted, it's not in as many cases as it is for the prosecution, but like we talked about earlier, like the advancement in forensic evidence is responsible for quite a few exonerations of those who have been previously convicted, whether it was because there was a lack of science at the beginning, or because originally maybe less accurate science was presented.
Well, personally, I think a lot of defense attorneys get a bad name solely because they're looked at as an extension of the actual criminal, the
Right.
defendant. And I love the way you just put that, because it's not your job to get this guy off
Right.
if he's guilty. It's your job to defend the process, because if the process is broke down somewhere, and it doesn't matter if it's anywhere from the beginning where the crime scene was contaminated all the way through to the prosecution is making up evidence, and those are all just, hypotheticals, of course. But
Right.
I love the way, like I said, the way that you just put that is that your job is to defend that process and make sure that if the process wasn't followed correctly, then by nature of the Constitution and the rights of the individual, that person has to be exonerated.
Exactly. And so but that can take form in a lot of ways, whether it's, the attorney filing pretrial motions because they think the evidence was collected illegally, or if they think that the prosecutor, kind of like what you were touching on, was trying to get into aspects of prior bad acts or convictions that we don't think are, actually admissible by way of law, or even if they are just so overly prejudicial that they would negatively impact this case. So we ensure that that information doesn't come out during the trial. And so I think, yeah, if you actually break down what the defense attorney is doing on the case, when you look at it from the point of view of them being a safeguard to the process, it does make a lot of sense. And absolutely, there are people and clients who benefit as a result of that. I don't even necessarily, everyone always asks, like, do you ask or do you know whether or not a given client actually did the crime or not? And I think it's very common that most defense attorneys say that it doesn't matter. And that's because it doesn't. Like, our job is not to, like you said, get him off. It's, are the prosecution able to legally and fairly go through the evidence and establish it in a way that would lead the juries to come to a just verdict? And if, they don't, I always tell people at the end of the day, and it's not to bash them, it's not to talk ill on them, but like, if a defendant or client were to get off, and people think that don't think that was the just verdict, and instead of being angry or mad at the sleazy defense attorney, honestly, the burden has to fall on the state, because that's where it started. When they bring a case, they're doing so with the burden that they have to prove beyond a reasonable doubt that they have the evidence that can lead to a conviction. And if they don't, yes, the defense attorney can play a role and highlight deficiencies or, alternative theories. But, you know, just going back, that if the police have done their job right and the prosecution have done their job right and the judge has done their job right, a just verdict should happen.
Everything's not 100% apparent just in what people are hearing about the case. And that's,
Yep.
I've sat through quite a few, well, I shouldn't say quite a few, but I've sat through enough trials and interacted with enough of the, especially on the front end of things, the crime scene investigators, the detectives are the ones that I work with personally the most. And from our perspective, it's our job to provide them the best equipment possible that they can get evidence that is rock solid. But even a DNA profile is just one wheel in the cog. Or one cog in the wheel, sorry. It's not convicting. You just because somebody's DNA profile is on evidence doesn't necessarily mean that they committed the crime. And there's a whole slew of things that has to happen in between discovering that DNA, and regardless of how it got there. But say, for example, there's a case here in Utah where the victim's name is Crystal Bislanowicz, and this was happened back in 1996. And this is kind of one of the first cases that actually put the MVAC on the map, is because the murder weapon were a couple of granite rocks, maybe about that big, 10 pounds or so, big enough that it could cause a lot of damage, especially with the sharp edges and things of granite, but small enough that somebody could grip it with one hand. So all they had was the victim's body, a pair of socks that was folded up on a rock close by, and then a bunch of these bloody rocks, two in particular that obviously caused the majority of the damage. And based on that, the investigators really had nowhere to go. And so that case was cold for 18 years. Well,
Wow.
Finally, the investigators learned about the MVAC. They used the MVAC on those rocks, and they got enough DNA, actually 42 times more than what they actually needed to produce a good profile. So, and the majority of that DNA that was recovered was one particular individual. But even with that DNA itself didn't convict Joseph Simpson, the man that was convicted of the crime. That was just one piece. And in that particular case, I sat through that whole case, obviously, because DNA played such a major part of it. Even with that, they still had to put Joseph Simpson in the area. He had to have access to the victim, all these other things that they had to put together. And yes, DNA was a major part of that, but there's no way anybody's going to get convicted solely based on one piece of evidence, or at least they shouldn't, I guess I should say.
I think obviously it can kind of depend on as to what that evidence is. I think in the majority of cases, that's an absolutely right stance to have. There are the few cases where there is the smoking gun, where, the one piece of evidence is that it's on video, happens, but I think those are so rare. I mean, trial and crimes aren't that in a vacuum. And there's so many components and different moving parts that very rarely are you presented with such a, smoking gun kind of thing where
Even it doesn't happen like Law and Order shows that it does all the time.
Yeah, no, it takes a little bit more than 30 minutes to go from the crime to the whole process. So, and that's definitely one of the things that, during a trial, we always have to kind of address and overcome that. Look, this is not Hollywood. This is not, your favorite law drama TV show or your favorite movie. And sure, there might be parts that reminisce them, but this is real life. This is a real people. These are real crimes, and these are real consequences. One of in the mantras of members of the jury, we say, we take you straight into the trenches of justice, where the passion, players, and consequences are real. And that's not the case in Hollywood.
Well, my understanding is pretty much it's called the CSI Effect, because CSI was the first major show that kind of dramatized the whole process. and the ability for a crime to occur, be investigated, and be prosecuted in 43 minutes just isn't reality. But unfortunately, there are some jurors that actually expect it. And by
Right.
watching shows like that, they'll say, well, if this guy doesn't have solid DNA evidence, then he's automatically exonerated. And that's not, that shouldn't be the case. But on the other side, if he have a solid DNA profile, he's automatically convicted. That's not the case either. And so, again, like you said, the fact that this is real life versus the Hollywood version of it, I think is so critically important. And jurors have to be objective when they're looking at the evidence.
I think that was a great way to put it, because that honestly, like the establishment or the creation of the Hollywood dramas, they affect both sides. It's very easily, like you said, for a juror to be like, well, I've seen those shows. I know that if they have the evidence, they're good for it. And that's not always the case, especially if it's circumstantial evidence. But on the other hand, as from a defense point of view, it's very much so that we could say members of the jury, we are all familiar with the types of evidence that they're able to collect that one would expect to have been collected on in this kind of case. And so where is that? It allows us to ask more questions. And so I think it's really important that, especially during that voir dire process, that we're able to pick and parcel between the jurors who are able to separate themselves from their Hollywood dramas that they're familiar with, and those who aren't. And those who aren't, we try to get rid of.
Well, so interesting. So, hey, as boy, we've been talking about this. It's so amazing when you get into these really super interesting topics that you just keep. They just keep going. It's like
Yeah.
we could be talking about this stuff all day. It's just so interesting, and I think that's why audiences, especially in the true crime genre, they just absolutely love this stuff, and justifiably so. I do too. Exploring the different aspects of true crime is, to me, whether you're talking about a particular case, talking about different job responsibilities, to me it's just fascinating stuff, and that's why I love it so much. But also, because it's never ending, we can always have you on again, so we can explore different things later. To
I'd
end,
be happy. I was just say one of the things that I would say, Jared, is that I think that this podcast, all things crime and members of the jury, they're bringing really interesting takes on true crime. I think so much of the true crime space has been investigative journalism's kind of breaking down cases after the fact. And what your podcast and my podcast is, I think, introducing to the true crime space is more current and like real time breakdowns of, obviously with the MVAC that's happening, that has happened and that is happening currently. There's cases and situations where that's being involved. Similarly here, like we're breaking down happened really recent in time, and we're also talking about current events. And obviously, a forensic evidence collector and a criminal defense public defender, those are really interesting, unique perspectives that in my kind of review and research of the true crime field, didn't see a whole lot of. And, there was a lot of investigative journalism, which is great and super entertaining. But I think these are really nice, fresh takes and insertions into the true crime space. And I agree with you 100% that, I could be here all day, and, we could be and having, give you, a whole year's worth of shows just in one recording. But, we
yeah.
got things to do. And, I would love to come on any time again in the future.
Yeah, absolutely. We will certainly have you on again. But before I let you go, you got to tell me something that is just when you're at Thanksgiving and people are saying, "What's the funniest thing that happened to you this year?" You've got to have some stories in your back pocket.
I do. It's semi embarrassing, but like, if you actually know me and get to know me or see me in court, this story makes so much sense. So obviously, with our courthouses being closed, a lot of the entirety court process has moved to a virtual setting. I fell victim to the infamous "thought I was on mute" scenario, where I had just raised it's called an invitation to dismiss to the court based on basically the set of facts and the time that had gone on from the date of incident to the time now the court was finally hearing the case. So I made my motion and I swore I put myself on mute. And just as the prosecutor started to go into his rebuttal as to why obviously the case shouldn't be dismissed, a gardener who kind of works on like right by our property, he wasn't actually on my property, but he was on my neighbor's property, but he had worked his way up to where he was like right by where I was, in my home doing the virtual court hearing from. And thinking I was on mute, I ran outside stupidly with my computer as opposed to just leaving it there. But I wanted the court to see me and know that I was still listening. Well, I try to get the gardener's attention, so I'm screaming. I'm like, "Hey!" And he's like not hearing me because he has his loud air blower on. And so I'm like, "Hey!" Like screaming at the top of my lungs. I was like, "I need you to stop for like 5 minutes so I can do court." And so he stops and I run inside. I put my computer down and I'm like standing there and I realize that like everybody's quiet. And the judge stops and goes, "Mr. Hirsty?" And I go, "Yes, Your Honor." He goes, "Did you just yell at the gardener?" And I said, "I did, Your Honor. I'm super sorry. I thought I was on mute and I couldn't hear the prosecutor. And I thought that was really crucial information that I heard." And he was like, "Well, my God, Mr. Hirsty, he was just trying to do his job." And I said, "I am too, Your Honor. I'm sorry." And so, yeah, anytime I'm before that judge, he jokes around a lot. He always asks me to make sure that there's no gardener around, and so that's a story I'm able to look back and laugh. And even though it's different because in the courtroom normally you'd have a handful of people, maybe 5 or so lawyers, and a handful of clients and people there for court. In the virtual courtroom, you have upwards of like maybe 50 lawyers and court personnel staff, just because there's so many more moving components in the virtual courtroom than there are in the real courtroom. So that's definitely been a funny story of mine during the COVID sagas.
Oh, that's funny. Well, at least they didn't catch you in the bathroom.
True. I've avoided that embarrassing experience. I've not
Yeah.
fallen victim to that.
Well, as you started telling the story, the wheels were also spinning. I'm like, oh my gosh, I can't imagine some of the things, you say, I forgot to put myself on mute. Then I looked over at the client and said, "You're screwed, dude."
Yeah,
Fortunately,
no,
fortunately, that
well,
didn't happen either.
that has happened, unfortunately, especially because the way that the process works is that oftentimes, especially for our in custody clients, is we have to call them over the phone and talk to them. That's off the kind of computer screen and stuff. And there are occasionally, there hasn't been anything like too crazy because people jump in right away and say, "Hey, you're on mute," or I think the court has the ability to maybe mute different screens. But yeah, that where they thought they were having this whole off screen and off mic conversation wasn't, so people had to interject pretty fast. So
Wow.
it's
Yeah.
definitely a change doing things online than it is in real life.
That is 100% for sure. It's absolutely crazy what we have to go through compared to what we did just one
Right.
year ago. I think everybody has basically had to convert themselves to some kind of a virtual something. It's interesting. I have a guy that I'm taking like some coaching classes with as far as presenting. And one of his things is he said, it doesn't matter who you are, everybody is a virtual presenter now, because whether you're in a boardroom, whether you're talking to a client, whether you're talking to a defendant, it doesn't matter. We're all virtual presenters now, and we have to present ourselves in ways that we never thought we would ever have to just a year ago. So interesting.
Very. And that's such a true statement. I mean, everybody, it literally is, because I mean, as of now, everything is done online, and it's just such a different way of communicating and conversing and being able to get your point across or even persuade. So, hopefully, 2021 changes us back. We pivot back to kind of the world of normalcy. But I think that, I think certain components of things will forever be changed. Not all virtual stuff that came out of result of COVID was bad. I mean, I know that at least us personally, or in my jurisdiction, we have actually a little bit better access now to our clients, whether it's especially with video conference telephone calls. Those were kind of far and few between. We would much rather just go to the jail. But now, especially for convenience sake, to be able to just organize a Skype call with your client who's in custody is really beneficial, and allows you to, kind of talk to them more. And also, because it's video, get that kind of human to human interaction as opposed to just talking through a telephone.
Well, like I said, fascinating stuff. So
Absolutely.
I appreciate you coming on, and yeah, let's definitely do this again.
Thanks so much for having me. And I look forward to it. Hopefully, I'll have a couple more stories once the courthouse is open, and we get back to, our day-to-day stuff. Cause yeah, I love this talking about this stuff. I love learning about this stuff. You've already talked about a couple things that I plan on going to look up and into because they just sound so fascinating. And, this is truly a passion of mine, and I just absolutely love it. And so thank you so much for having me. It has been an amazing, amazing experience.
Oh, the pleasure's all mine. Yeah, definitely tell your friends.
Will do. Take care.
Okay, see you later.